My lords, the challenge to a proviso to the Odisha Elementary Education Method of Recruitment, Rule 97 in 2019, my lord. That is to exempt the persons or the teachers who are already there from or before 97 onwards.
Yes.
After the coming of the Education Act, Central Education Act, and also there is a problem which is added to those acts that it will be a TET, teacher eligibility test, is required for the purpose of their. So TET is held in Odisha in 2012, my lord, for the first time.
Yes.
In order to rationalization, the state government passed an amendment saying that those people who are there before 2012, that they are exempted from the, presumably with a observation that it will retrospective effect should not be there. So neither the Education Act, Central Education Act has got any retrospective effect, nor, and the TET was held, and all the petitioners before your lordships, they are 2012 and thereafter they have been recruited. So the former is a class of themselves because at that time there was no TET test when their recruitment took place. They have got all the other qualifications as per the Odisha the Education Act. All the qualifications are there, but they never had a TET because there is no concept of TET at that time. That under my lord, challenge, my lord. So, my lord, already, my lord, I have heard this matter for a long time, so I will not take a lot of time. The action of the state is under challenge, whether they can go in for a exemption clause. What is they are saying that we have exempted. My lord, kindly see the inside there is another dates and events where page 4, my lord, page 4 of this note, my lord, which is a note. First is a date chart that provided that the top portion, my lord, of the rule that impugned rule is quoted, my lord, here. Provided that the teachers appointed against the advertisement published prior to 11/2/11, my lord, are exempted from passing Odisha Teachers Eligibility Test 1 and Odisha Teacher Eligibility Test 2. This is the notification which my lord and friends have challenged. And on the ground that this is a mandatory requirement, you cannot give a decision. Because our argument, my lord, is that it is both this education is both in a concurrent list, my lord, and unless there is a repugnancy of the two, then they can, in the field, independently they can remain in the field. When you take up the case of these teachers, my lord, who are already appointed, my lord, kindly see, that is why I have given 9 before 97. Their appointees of 97 and also before 97. So, when they are appointed, there is no such requirement. But in the midway, when the teacher that Act 9 came into force, 2009, and thereafter, NCET is the educational agency to look into this. That came in Odisha in particular date is there, my lord. It was held on. That date is important, my lord. I am just. Uh, 2012. I am just pointing out, my lord. Four 6/2012, my lord. 4/6/2012, page 2, top portion. That is the date on which the examination of TET was held. By that time, there was no TET in Odisha.
4/6/2012, in your date chart, there is no date.
Oh no, I have put it in here, my lord. Page 2, my lord. Of the next note, my lord. Next note, my lord. Page 2, para 4, my lord. Para top. So that is the rationale, my lord, of this. Therefore, my lord, some people may be 30 years old or very aged person, those have been appointed and continuing.
30 years is aged.
No, 30 years in service, my lord. Because there were previous, before 97 Act also, there are teachers and they were regularized in that 97 enactment. So therefore, to give a class of these are a class who never had a TET in their entire service career. At the end of the almost end or middle of their service career, this rule came into, the central rule came into force, which was also adopted by the state. And that, when looking at the difficulties of those situations, the amendment is made. That is, my lord, the only point which, and it is not that it is in repugnancy to the other act, because the other petitioners, they are appointed after 2012. So they are already there, and already that rule was there. The appointment is necessary. So that is a difference between these two set of employees, teachers before your lordships. And
Yes.
therefore, my lord, all these things I will not repeat, my lord, because my lord, I have already gone through this. I will only take you to page 6, my lord. Page 6 of second submissions, my lord. 14, 15, and 16. I will read, my lord. 14, 16. That in the aforesaid cutoff date is derived from the guideline issued by NCET. Actually, NCET gave a kind how the TET will be held. So thereafter, we went in for a test. So that is why that date in the cutoff date, that 11 cutoff date, that 11 to 11 was derived. That was the date on which the NCET submitted directed the state government how to hold a TET test, and that is the date on which we have given that cutoff date, my lord. So my humble submission is, my lord, these teachers which are already there by virtue of another state act, and they are continuing in a cadre. Already there is a cadre, and they are continuing as per their seniority and other things. So they are suddenly they are asked to that if you do a TET test, then you are to suffer. That is to mitigate that situation, which is in my humble that it is not unjustified.
No.
this year has been made, and there is no repugnancy, my lord. So 14, 15, and 16, I am reading, my lord, only. That the aforesaid cut-off date is derived from the guideline issued by NCTE under the agency under Section 23(1) of the RTA Act, the conduct of TET and RTE Act for the first time, and basing upon the OTET, the first time was held on 4/6/2012 method. And therefore, date of said guideline by the NCET has an access to the cut-off date provided in the provision having an access to the purpose to be achieved, and the RTA Act 2009 has advertisement has never any chance to appear in the TET and OTET test, since there is no guideline of the NCET on behalf, and therefore the exclusion at the entry level and thereafter cannot be declared as ultra-virus of the Constitution or repugnant to the Central Act. And teachers are a class. These teachers are a class by themselves, being appointed before
they may be class in themselves.
Yes, my lord.
And therefore they cannot be their services.
No, that is exactly the yes, ma'am.
Their services may not be dispensed with on that ground. But when it says that for promotion, the NCTE guideline specifically says the regulation specifically.
My lord, that we have already opened our card. My lord will decide those things, my lord, because it is already on the wisdom of the state government. They have done, because there are a lot of people there in the teaching.
No, we are trying to. In fact, we have also.
Yes.
According to you, when they lay down qualification, minimum qualification for promotion.
Yes. No, many of the promotion in the old 97 Act also.
So they might have they cannot be disturbed.
Yes, madam.
But now, when it came into force, the regulations came into force when?
The regulation came into force
2014. Amendment 2014.
Yes,
which prescribed TET to be a qualification.
Yes, please.
In 2015,
My lord.
This was introduced that TET shall be a qualification
My lord.
for promotion.
Obliged, ma'am.
Then how can you ignore that?
My lord, it's a transitional period, my lord. My lord, can we see from one type of legislation to another legislation? That is why, my lord. Otherwise, my lord, if for any other person's government wants to relax, they can approach the state central authority to take a view, and thereafter they can do it. But here is a transitional period, my lord, where both the acts are now merging with each other.
No,
that is,
would have framed the rules in 2011.
my lord, it was never, my lord, that timing, my lord, I am not disputing, my lord. Then,
all right. Anything else?
this is the whole thing, my lord, only because that is only that why we made this act and this amendment, and it is only a transitional period and it is not a permanent nature. People retiring and they will be going, and therefore, my lord,
Let us see the provision again. Where is that?
my lord, that provision is, I have quoted it.
My lord, that is Annexure 8,
No, I'm
page 69.
I have taken it in. Page 4 of the second note, my lord, the top.
No, not that. Not Annexure 8. The provision which you are challenging. My lord, we are challenging at Annexure 6. That is page 59.
No,
My lord, your lordship will find my compilation that I have put it.
no, just a minute, just.
I have put it. Just a minute.
I have quoted it in my
1D
note, my lord. That is page 4. Page 4 of my second note, my lord. Page 4, top. My lord, I have quoted that, my lord, in my.
It is in the education manual also.
No, no, it is.
Page 529.
No, no. For your convenience, my lord, I have quoted that portion, my lord. Page 4, top paragraph, provided that the teachers appointed against the advertisements published prior to 11/2/11 are exempted from passing Odisha Teachers Eligibility Test 1 and Odisha Teacher Eligibility Test 2, my lord.
Page 66 of the brief.
No. Move it up.
I told first brief.
First brief. Yes, ma'am.
In the education manual that is there.
It is there also in the brief.
Page 529.
$529.
Yes. D. That is top in 530 page.
Provided that
Orissa Teachers Eligibility Test 1 for Category 1 and Orissa Teachers Eligibility Test 2 for Category 2. Which was the 1st March 2009. It is there. Page 7. Last page. Page.
Which
Yes,
makes
madam.
it compulsory.
Yes, my lord. But may I, my lord, refresh your, my lord's.
No, just let us read. Don't have to refresh our memories. Just let us read that again.
My lord, section 23, that is page 2. By virtue of 24th of 2017 amendment to the RCFC Act with effect from 1/4/2015, provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualifications as laid down under subsection 1 of the section 23 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right of Children for Free and Compulsory Education Amendment Act 2017. This is the act. But the RCFC rules also provide the how the relaxation the state government can seek. Union territories and section state government can seek. That is next page. That rule came into force in 2010. Central rule, so also the Odisha RCFC rule. Both bears the same provision in consonance with section 23. They have to move a proposal that is to be examined by the central government, and central government only can relax if satisfied. And they have relaxed not one, 2 occasions, and thereafter Parliament by way of amendment incorporated this proviso to section 23 by fixing a cut-off date. By this date they have to give in the last chance as 4 years they have to acquire.
So, what is the academic? What qualification has been prescribed by the academic authority?
Yes, my lord, that is at annexure 2 to the brief, dated 23rd August 2010 at page 29. My lord, may kindly have classly just the better copy I had handed over. Now I am also my copy, your lords. To be decided to what the section 23 says, my lord. They have given the what is the section 23 says, madam. Well, section 23 says in the compilation that I have, it at page 2 of my, that the central government can relax. May I read, madam? Where a state does not have the adequate institution offering courses.
Until in 1997, has not passed TET despite the provisions. What will happen to it? What is the consequence?
Consequence is, no, I am not saying that they will be thrown out because
According to you, it is not that law. We just want to know that if someone does not acquire the qualification of TET, what is the consequence under the law?
Before the relaxation was given, there must have been some consequence for which this relaxation came. So what was that?
No penalty or no negative provisions was prescribed under the Act.
But any,
Only relaxation was extended.
For what?
Time to,
why was it
to
extended?
acquire that qualification if not acquired.
If they don't acquire, what will they, what will they be deprived of?
Then certainly they cannot be substantially able to hold the post, after 2019, not prior to that.
So this is, according to you, the consequence is that they should have been removed.
No, from the post of promotional, if it will be read.
This is promotional post is your inference. This is your inference that promotional posts cannot be considered for promotion.
Yes, my
Because for promotion, that is the minimum qualification.
Yes, my lord.
This is your inference. This is how you deduce on the basis
And on the basis of the regulation 2014.
on the basis of regulation come to section 23(1).
23(1). Yes, but any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as teacher.
This is over. Because this will not apply to person.
Yes, Malad. And two has looked after them.
Yes, see, two,
Malad. Where the state does not have the adequate institutions offering courses training in teacher education or teachers possessing minimum qualification as laid down under
different circumstance. Two deals with different situation. Whether you
first proviso, Malad. Two added with the two proviso. First proviso which was existing with the Act. Second proviso came in 2017. First proviso says provided that a teacher who at the commencement of this Act does not possess minimum qualification. This is important. This is existing from the day onwards. Teacher who at the commencement of this Act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 5 years. That was expired. Thereafter, with the relaxation was extended even after 5 years. Thereafter, the Parliament thought it appropriate in order to achieve that the goal of quality education of 8G, what